Hi there, folks. This is Sam Price with Probate Notes, and I have the great pleasure today to be speaking with Kevin Sayles, Vice President and Probate Expert at Lawyers Title. Hi, Kevin. Thanks for being on today.
Oh, thanks a lot. Hi, good to be here.
Well, I just wanted to get started with asking you a little bit about you. Where are you from? What's your background?
I grew up in Los Angeles County, Laverne primarily, and I lived a couple years in Seattle, but grew up in Laverne. I'm a graduate of University of Laverne and started working started a regular career after graduating college. So that was 1993, and I started in banking. And I started my career in banking. I was in a management training program, which is like the program I was in was like getting a master's degree in banking and finance. I did everything. I did two appraisals during that time. I mean, technically I didn't do the appraisals because I didn't have a license, but the appraiser walked me through doing two appraisals. I learned lending. I had underwriting authority at the age of 23 or 24 years old. All these different things that I did, which I still use today because now I use my underwriting background from lending underwriting and title underwriting. And, a lot of what I learned when I got to a title company in 1999, I learned how much I knew about title and escrow because of the things that we had to do on our lending products there at the bank. So my background started in banking and lending, and I've been in title since 1999.
Well, how did you get into title insurance work?
That's a great question. Okay, so I had this lending background. I was working for Home Savings of America at the time. I had gotten a promotion. I had been a branch manager, and I was promoted to a training manager. I was in charge of training in California, Texas, and Florida for all the branch personnel. And Home Savings got bought by Walmart. So I remember I had like a 4-month period where I had probably 1 week's worth of work to do in 4 months, but we were winding down facilities and closing things down. So really they had a lot of career transition resources that we were supposed to use during that time. And I did that, and I applied for a job I thought I was applying to be a lending manager at Countrywide Home Loans, but they called me because they were looking for someone who had lending background and knew training management. And I had all the certifications. I had certifications to create training programs, to write training material, et cetera. Like my resume fit perfectly for what they were looking for. And so I go to this interview thinking I'm interviewing to become a loan manager at Countrywide, and they wanted me to be the training manager at their title company.
You got
And
bait
so,
switched.
well, yeah.
You bait
And I'm
switched.
like, oh, I thought I had two resumes, right? One was a training manager emphasis. One was a lending manager emphasis. And I walk in with my training manager emphasis resume. I'm like, oh shoot, I brought the wrong resume. I mean, I'm sorry, the lending manager resume. And I was like, I brought the wrong resume, but my background lined up exactly with what they wanted, and it worked out. And it's funny because Countrywide was known for hiring when it's busy with refis and then firing when it slows down. And I hired a staff and then laid them all off within 8 months. So within my first year, I realized, okay, I need to get back into just working in title, not so much being the training manager for the title company. And I got into, I became a sales manager there for that first title company.
So now taking that to a probate case, because the owner of the property has passed away. So now what do you have to know in order for us to make sure that whoever is going to sell the property is the right party that should be selling that property?
Yeah, it makes it a lot more complicated. And it's very crucial. This is why when there's a probate case, there's court papers that we have to see.
Yeah.
There's a death certificate that we have to see for multiple reasons. And then there's some background systems where we can check and say, okay, is this John Doe decedent? Is this the same John Doe that
Yeah.
owned the property? And so we use that data to check it out. When it comes to the case, for a full authority case, we're going to get copies of the letters. We're going to get a copy of the notice of proposed action, filed copy, and then information from the attorney where the attorney will let us know if there's any estate taxes are due. Those are some of the things that we require in order to close, along with a copy of the death certificate so we can check the information on that death certificate to the information on the records that we have for the owner of the property.
No, that's perfect. So that makes sense because since Jane Doe has passed away, if now John Doe is the personal representative of the estate of Jane Doe, then we need to know that John Doe was properly appointed by the court. And that
That's
is
right.
his letters and the death certificate showing that Jane had passed away. That's what you need. And then if the personal representative has full authority under the Independent Administration of States Act, we can take that notice of proposed action so long as no one has objected to it, and we can close escrow. So I've had cases where we've had to ask the court to remove the house from the title of the trust and put it into the name of the decedent's estate. Is that the right way that you would want to see that as a title company?
Yeah, yeah. If they do not have a copy of the trust, then they essentially died intestate. And so the property has to be taken out of the trust and put into the estate for the individual. And then a probate case would be used to sell that property. And
And
unfortunately, it happens all too often where they
yeah,
can't find their documents. I have a situation I've been dealing with the last couple of days where there's a power of attorney that is being used and they can't find the original power of attorney. These original in this day and age where so many things are, an email or a scanned copy, there's still some times when we have to have original documents. On a trust, we don't have to have the original, but on a POA, we do because we record the POA and we can't record a copy. It's very important that people maintain the location of these documents because without them, sometimes we can't really move forward.
when I had that case where we had a house titled, transferred to a trust, but we don't have the copy of the trust, the judge made sure that I looked up in the top left corner of a recording, it says recording requested by. And so if it says the name of someone there, I need to go find that person.
Yeah.
They made me look up the notary public because the notary might have worked at a law firm or something and possibly might know where a copy of the trust would be. I had to do a lot of due diligence to figure out who might have this trust if a trust is out there before the court would determine and put the house back into the estate.
Sam, that's amazing that you know those things and that you do those things because that is very, very important. The other thing in the top left corner will say when recorded mailed to, sometimes that mailed to address, there's a copy that was mailed there. The other thing is sometimes on the document, you'll see, I even seen it in the footer of the document, like on a Word document, it'll say
Mhm.
the name of the document. I've even seen in the footer, it'll have like the law firm name
Yeah.
or the attorney's name. And we've had situations where we found the deed, putting the property in the trust, found the attorney from the deed because their info was on there some kind of way. And then the attorney had a copy of the trust. But yeah, it's like private investigation work that we have to do to try to find them. And if we cannot, then we're kind of stuck.
What does a title company want to see now that the title is in the name of the three beneficiaries individually from the trust?
Okay, so when they distribute that from the trust, we are always going to have to see a copy of the trust. That's why one of the things that I try to get out there as much as I can when I'm talking to people is always keep a copy of it. As long as the property is in the family, keep a copy of the trust because we don't know, all we're going to see is what's on title. John Doe or Jane Doe, trustee of the Doe family trust. And then, you know, Sally Doe, successor trustee of the Doe family trust, hereby grants to Sally Doe, Steve Doe, and brother Joe Doe. That's all we're going to see, what's on title. We don't know what the trust says. The trust might
Right.
say Kevin Sayles is supposed to act as successor trustee. The trust might say Sam Price is supposed to get the property when Jane Doe dies. We don't know what it's going to say. It can say anything they want it to say. And so it's important for us, it's important for the future that they keep a copy. I have this I was going to say great case. It wasn't great because it wasn't very nice for the poor person. And here's the scenario. We have grandmother on title to the property in the late 80s. Grandmother's trust gave the property to daughter. Daughter is the daughter of grandmother, right? Or mother of granddaughter, which I'll talk about in a second. So the property went from grandma's trust to her daughter, and then they had it for a while, and then it went from the daughter, which is mom of the granddaughter, it went from daughter to granddaughter. Okay. And granddaughter was going to do some financing. Granddaughter produced her mom's trust, but there had been no title insurance in a long time, and there's no record. So what was required at the time is we need a copy of your grandma's trust because grandma's trust could have said anything, and we don't know what it said, and we're not sure who is the successor trustee and who's supposed to receive title of that. So we have to see there's two trusts that we need to see in that case, because it went from grandma to mom or daughter, and then
Oh,
from daughter to
wow.
granddaughter. And we have to see both of those to know that grandma's trust was administered property, or right. And then we have to know that mom's trust was administered property to get this to them. And so it's a problem. I always tell people, when there's a trust and you're distributing from a trust, keep a copy of that trust forever, or at least as long as that property is in the family.